I was suspended for breaching the rules on recruitment back in September 2016, and those of you listening will probably remember you mentioned it, I think, Crispin, about the leadership election that was going on and whether or not Jeremy Corbyn should be on the ballot, which was a bit bizarre, wasn't it? That's like saying, I wonder if Usain Bolt would win this race, but let's not have him in the race and let everybody else run. You know, it was stupid, wasn't it, really? So what had happened is at the time, I think the NEC did meet to determine that Jeremy Corbyn could be on the leadership ballot, but at the same time, they also said that members who joined after, I think it was the 12th of January 2016, would not be eligible to vote unless they registered as a supporter and paid £25. Now, this was specifically aimed at that cohort of registered supporters that had joined, paid their £3, to sort of be a registered supporter of the Labour Party. So these people were completely disenfranchised. It was almost like a voting tax that they had to pay to vote for the candidate of their choice. And there was a group of us at the time on social media. I remember it was quite late in the evening, I think way past my bedtime actually, and we were having this debate. Most of us said, that we felt it was, a terrible, terrible decision. And so we decided that we didn't want to give money to people to vote, but we would set up a crowdfund and say, you pay the £25, and obviously if you've had to utilise that £25 from your food bill or from the money that you were keeping back to buy your child a coat or for your best fare back and forth to work, we'll give you money towards that. And that's what we did. So as you can imagine, the NEC, the government, the Governance and Legal Unit, got to hear of this, and they contacted the person who'd set it up with crowdfunding, because with crowdfunding they've got to have a named person. So this named person who had sort of administered this crowdfund was contacted by Sam Matthews at about 3:30, 4 o'clock on a Friday, the 15th, I think it was, of July. I remember it well, and was told that within 48 hours she had to close the page and refund the monies to the people who'd made the pledge. So of course you can imagine at that time on a Friday she couldn't get hold of anybody to sort of discuss the legal implications, etc. So she decided, very reluctantly, but felt that it was the right thing to do, to close the page and reimburse the monies to the individuals who'd made the pledge. Now, some of you will understand, I'm sure, that the way the crowdfund works is you make the pledge, they take the money from your account and they keep it. That's obviously how they make their money, because they obviously gain interest on those monies that they're keeping. And then once the page is closed or the target is reached, they get in touch with the page organizer, and then the monies are paid to them and disbursed. So she did manage within that 48-hour period to get the page closed and get crowdfund to refund the monies. And obviously contacted Sam Matthews, and he said something along the lines of, oh yeah, thanks for doing that, I acknowledge you doing that, and there won't be any further action. And then several months later I was suspended for breaching the rules on recruitment, and I had no idea really what that meant. And I looked through the rule book and I rang Labour HQ, and they were as much use as a chocolate fire guard, wouldn't sort of tell me anything. And I mean, cut a long story short, I think I was just so incensed. I was so incensed at the way that I had been treated. And it wasn't just me, it was other people who probably, because of my experiences, because although not a lawyer, I work in a legal department within a very large, one of the largest government departments. So I am a litigator within that department, but a non-legal one. And my background as a nurse within the NHS for 10 years and lots of other jobs that I've done has brought me to a place where I don't take many prisoners, and if I see that something is wrong, I will do something about it. And I just thought, I am taking these people to court for breach of contract and for breaching the Data Protection Act, and that's what I did. So those amongst you who know about these things will know that when you make a claim to the county court, one of the things you have to do, because the courts are very big on it, is say whether or not you would be amenable to alternative dispute resolution. And I actually was, as you can probably tell from listening to me. I love to talk and discuss things. So I put in the claim that I would be more than happy, you know, to have a round table meeting without prejudice and sort this out, you know, let's be grown up. No, they didn't want to do that. I thought, hey ho, there you go. So we continued on the path, and I put in all my evidence and put in a witness statement. And I think what happened is, at the time, the Governance and Legal Unit didn't actually have any legally qualified people in it, as I understand. And so they were outsourcing their legal services to external counsel and solicitors. And that's what happened in my case. So I had put in a witness statement, and basically everything was in there, chapter and verse, with supporting documents exhibited to the witness statement. And so I think what happened is, when a real lawyer looked at my witness statements and all the evidence, they thought, shit, we need to do something about this. And at 2 o'clock on a Saturday afternoon, just before Wales were about to play Scotland in the Rugby International, I received a phone call from Ian McNichol's solicitor. And he said, oh, my client is concerned about the costs. I said, is he? Is he really? I said, because he wasn't concerned about the costs. When I said about alternative dispute resolution, it was turned down flat. So sorry if I don't believe that. And he said, oh, well, would you be prepared to withdraw? I said, absolutely not. And he said, well, why not? You've been unsuspended, because what had happened is, because I put in this claim, they had unsuspended me, but they had left a warning to remain on my file indefinitely. Now, as criminal lawyers, if there's any listening, will know, under the Rehabilitation of Offenders Act 1978, any conviction is deemed to be spent after a period of time. Now, obviously, the more serious the offence, the longer the record will stay in force. And that's because it's obviously what it says, rehabilitate offenders into society so they can take up employment and contribute through their taxes to, you know, to society. And so this warning to remain on file indefinitely, Labour members were actually being treated worse than convicted criminals, which was just crazy. And I'd reported this to the Information Commissioner's Office under the data retention breach, and they'd agreed with me. And they said, no, they must objectively justify the length of time that they keep the warning on file. And so this was also running parallel to this court case at the time. So I'd said to the solicitor, no, I don't care if they've lifted my suspension, that's just not enough. I am not having a warning remaining on file indefinitely. So it's up to you, because the case had been listed for hearing on the Tuesday, and as I said, this was the Saturday. So he said, right, well, if I can get the warning lifted as well, would you agree to doing a joint application to the court to stop the proceedings? I said, yeah, I'm happy with that, if you sort that out. So anyway, within sort of like an hour, bearing in mind this is Saturday afternoon, he'd emailed me back with an email from Governance and Legal Unit to say that the warning was removed from this record, that record, this record, you know, and it was signed and everything. So I agreed to withdraw it from the court action, and the solicitor sent in the papers, which I had to sign, and off it went to the court. But because I am, I've got a suspicious nature, shall we say, I rang the court on the Monday morning and spoke to the clerk and said what had happened. And he said, oh yes, we've had the email in off the solicitor, so we're just looking for a judge now to sign the order. And I said, well, look, you know, really, until I get something from you in black and white, I should still turn up, shouldn't I? And he said, well, technically, yes. But he said, ring me back in about an hour and I should be able to confirm for you. And he said, then I'll email you and the other party, and that will be your sort of proof that there's no need for you to attend. So I did that, and I got the email. So he was lovely, the clerk. We were having a little chat, as you do. And he said, oh, well, he said, that's gonna cost them, you know, to put in the application now. It's going to cost them a couple of £100, because when you make an application to the county court, obviously there's a cost involved. And what was interesting in this witness statement, I think what did it was the fact that the Labour Party, the lawyers amongst you will understand that when they put in a defence to a claim, the Labour Party or an incorporated association or other type of organisations like that, one of the wording says, Ian McNichol, General Secretary of the Labour Party or the UK Labour Party, sued on behalf of all other members of the Labour Party except the claimant. And people were so incensed by the fact that their membership subs were being used for him to mount a defence against me, which, you know, they didn't agree with. They set up a petition against it, and I got blamed for instigating this petition as well by Ian McNichol, which wasn't true, and I proved that. So in the witness statement that I put in, I actually said that I do understand that the court does have the power to apply costs directly to the defendant and not the wider membership, especially if the judge felt that there was an abusive process or the defendant was abusing his position by unnecessarily driving up costs or being intransigent at the expense of the members. So I was basically saying, you muck about with me, pal, and you'll end up paying this out of your own pocket. And I was very clear that I was going to do that. And I think it focused their mind, in all honesty. And I think when they saw that I just was not going to go away, they dropped it all. I mean, you know, I think I was advised at the time, we'd set up a support group on Facebook, and it was fantastic. We had barristers on there and solicitors and trade union representatives, and they were giving me a lot of pro bono advice, for which I am eternally grateful. You know, it was so helpful, some of the information that they were giving me. I think that's what did it in the end, is that because I stood firm and because I sort of held up a mirror to them and their actions, I think they realised that once it went to court, there would be nowhere to hide. If they said something, they would have to show it. They'd have to provide proof, because they were making the allegation, and the burden of proof is on the person making the allegation, not me. I didn't have to prove anything. It was them that had to do that. And I think they realised, albeit late in the day, that, you know, I was best off being left alone. So, you know, Mark and Howard are right about what they say. You know, I can see it already about people being hyper vigilant and self-imposing these sort of restrictions on themselves on social media. But, you know, we should be allowed to say what we think. We should be allowed to do what we think, as long as it's not illegal, immoral, or fattening. You know, there is no right not to be offended. Obviously, there are specific rules around homophobia, racism, etc., and obviously things to do with gender recognition, things like that. But in terms of just the normal day-to-day banter that you have with somebody, you know, I think we are on a bit of a slippery slope, really, and I think we need to sort of just be aware of this. That Article 10 does exist, and it's not an overarching right, like the right to life, for example. It is a qualifying right, but it is something that we you know, we shouldn't be afraid all the time. You know, we do have legal routes that we can go down, and I do think, you know, I'm very angry about what's happened to Jeremy Corbyn. I hope he does go legal on them. I really, really do, because I think they've breached so many of their own rules, as well as the Data Protection Act. I mean, he was told about his suspension by a photographer, I believe. And I mean, that happened and is happening a lot, where people in the Labour Party, prior to the person being told they are suspended, will leak information to the media. Yeah. And then they talk about the member bringing the party into disrepute, but it's not, it's them, because they're leaking that information.